No, it's that you won't do anything that you're instructed to do.
No.
You won't identify yourself.
I ain't did nothing wrong. I ain't did nothing wrong.
I've explained that to you several times, sir.
You didn't explain nothing. I don't understand.
Okay. You're not allowed to leave your car running.
It wasn't running.
Okay.
It wasn't running.
And you can't have your music
and.
so loud.
It was not running. It was not running. My car was not running.
You can disagree if you wish to, sir. You'll have your day in court.
Hey, if they kill me, I ain't did nothing.
Now you're under arrest. Stop. I have to search you because you're going in my car because now you're going to jail. Okay? So I'm going to search you.
How do you want to plead?
Not guilty. I could be appointed lawyer.
You have to get your own. You got a full-time job. It's for people that are on.
Excuse me, I can't hear you.
You have a full-time job.
I don't have a job
Well,
because
then
of
you
this.
need to get one. You're not on disability, so you'll have to get your own attorney.
But sir,
Plus, I
sir.
don't think you were offered diversion, so I don't think he's gonna.
Because I'm
there's no
innocent
jail
till
time.
proven guilty.
Mr. Phillips, why don't you just go to diversion?
Excuse me, ma'am.
You were eligible for diversion. Why don't you just go? That way, you can get it over with right away, and then you can get it off your record right away.
With no disrespect, because I'm innocent.
I'm just saying.
I'm
you want to.
innocent.
And I do take offense.
I apologize. I wish
because
you
I
did.
knew you were going to since the day you came in. So I know what your plans are.
What is my plans?
You watch the news. I watch the news. Yes, it is.
But what are my plans?
Yeah. Just what you just said to me. Better watch out, Mr. Phillips. I have a tendency to get a little.
Excuse me, ma'am, I didn't hear you.
That's it today. Okay. The getting's good.
Told me to watch out, right?
Welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. Thank you so much for joining us, and as always, if you enjoy our channel, please do consider subscribing, liking this video, and interacting with us in the comments below. It really does help us out a lot in the YouTube algorithm. Today's video is brought to me by a subscriber via Facebook. If you have a video that you would like me to analyze, please send it our way. All of our contact information is located in the description below, along with all the links to the original videos and any case law, statutes, or other sources that we use. Eric Phillips was doing his laundry in an apartment complex when Officer Ulrich of the Covington, Kentucky Police Department approached his car because it was allegedly running while unattended.
Can we get one more? It's not emergency. 32, can you make it? Actually, scratch that. 12, can you make it? I'm from Covington.
265.
Go ahead, 265.
Be out with one from 101. Wait for a tag to go with us.
Go ahead.
Kentucky 846 Marytown, Edward. You have your ID on you, sir?
Do you need a second?
Thank you. No, don't tell people to show up here. You have your ID on you, sir?
What?
I don't care who it is. I don't need them showing up. You can't leave your car running unattended. I don't know what you
It
need.
ain't running.
Right, because I took the key out.
No,
because I
man, what
turned
you
it
mean
off.
you took the key? It ain't running. The key was tilted to the floor. It wasn't never running.
Okay.
Baby, he tried to say my car was running, and it wasn't running. You get what I'm saying? And he said he took my key out. Right here by the laundromat. By the laundromat, man.
265. Start me one more. Have a seat for me, sir.
No, am I being detained?
Yes. You are not free to leave.
Why, am I
22, go direct with 72.
You have.
He said I'm not free to leave.
Good, I'm trying to watch this.
You are not free to leave. You left your car unattended while it was running.
It was not running.
And you had the loud
You
music.
lying like a mother. It was not running. I kept my car. Hey! I did not keep my car running. I had my key tilted when the music playing. He tried to say I had my car running. He lied.
Okay, I'll hold it over here so we can have the unit, and I'll try to make
If you
contact.
keep yelling and screaming at people halfway across the campus here, I'm going to take you to jail for disorderly conduct.
In the Kentucky Revised Statute, Section 189.430, subsection 3, no person operating or in charge of a motor vehicle shall permit it to stand unattended without first stopping the engine, locking the ignition, and removing the key. Grammar is important when evaluating statutes. There are conjunctive and disjunctive laws. Conjunctive laws are interconnected via commas and the word and. Disjunctive laws would be connected via the word or. So in this instance, the law requires that in addition to stopping the engine, you must also lock the ignition and remove the key. This becomes important because Mr. Phillips argues that the engine was not engaged, which, according to the law, is irrelevant because the ignition was not locked and the key was not removed from the ignition. Therefore, the officer was correct in asserting that Mr. Phillips was committing a crime. Now, you can argue that this is a silly law. Its stated purpose is to prevent your property from being stolen by criminalizing a careless act by failing to protect your own property. There are some legitimate arguments to be made that this will limit pollution and also prevent the possibility of a child joyriding in a car left running. Regardless, it's the law in Kentucky, and Mr. Phillips was violating it, so the officer did have reasonable articulable suspicion and even probable cause to not only approach Mr. Phillips once he identified himself as the owner of the vehicle, but also to demand identification so that they could issue a ticket for the violation. Now on to disorderly conduct. Disorderly conduct in the state of Kentucky occurs when an individual in a public place and with intent to cause public inconvenience, annoyance, or alarm, or wantonly creating a risk thereof, he engages in fighting or in violent, tumultuous, or threatening behavior, or makes unreasonable noise. The government would argue that Mr. Phillips was making an unreasonable amount of noise in a public place. According to Com v. Jones, the Kentucky Supreme Court held that reasonable in this context depends upon the time, place, nature, and purpose of the noise. Unreasonable was preferred over loud because loud noises may be appropriate in some places and on some occasions. Therefore, it's up to the jury to determine if the noise was reasonable or not. Mr. Phillips was loud in a public place and in the evening. It would ultimately be up to a jury to decide if he was unreasonably loud or not given the situation. Several minutes pass by as Mr. Phillips is waiting for his wife to bring him his identification.
Stay right here. I don't mean no harm to you.
Well, I don't know you from nobody.
I don't know you from nobody, and I mean
Okay.
no harm to you. You
All
got
right,
a gun.
then have a seat for me.
No, all I need to have a seat for. It's wet
You're
on
gonna-
this ground.
You're going to refuse to do
I'm
anything
not
I ask you to
refusing
do?
anything. It's wet on this ground. Why do I need to sit down? I'm cool right here. Want me to have my hands up so you can feel safe?
It's not that I don't feel safe,
What do
sir.
you feel? What's the problem?
Well, your attitude makes
My
me
attitude?
concerned.
I got an
That
attitude?
you certainly do.
Want me to tone my bass down? Is that what y'all afraid of?
Your bass
In my voice.
and your voice. No, it's that you won't do anything that you're instructed to do.
No.
You won't
First of all,
identify
first of
yourself.
all, I ain't did nothing wrong. I ain't did nothing wrong.
I've explained that to you several
You
times,
ain't
sir.
explain nothing. I don't understand.
Okay. You're not allowed to leave your car running,
It wasn't running. It wasn't running.
and you can't have your
No, ain't no
music
and.
so
It
loud.
was not running. It was not running. My car was not running.
You can disagree if you wish to,
Ain't no
sir.
disagree.
You'll have
I
your
know
day
the
in
facts.
court.
I know how much gas I got in there, so that's for the simple fact that's not why I'm gonna keep it running. Come on, man.
Nothing further.
You can try your best. You're thirsty. Baby girl, make sure
Stop
he
yelling.
give you my keys. Cause it's raining. I don't know what they about to do. Let me hit my cigarette. What are you doing?
You're being detained in handcuffs at this time. Now you can have a seat. Sit down.
Pull my pants up.
Sit down.
Pull my pants up.
Your pants don't
Hey,
fit?
baby, I'm trying to tell him to pull my pants up.
Keep
'Cause
your
it's
children
wet.
away
It's
from
wet.
this. You do not need your children here.
Hey, that's
You
my
have
daughter.
no business
yes,
here,
you
ma'am.
do. That's my wife.
I don't care. You don't need to be here.
Baby, you ain't gotta leave.
It is not safe for me for people to be walking up. I don't care
She
what
ain't no
you
harm
heard.
to him.
Leave, or I'm going to put you in handcuffs in a
Don't leave.
police car.
Do not leave. Hey, don't leave, baby.
I don't care who's in your family, ma'am.
Don't leave. Hey, if they kill me, I ain't did
All right.
nothing.
Now you're under arrest. I've warned you several times about disorderly
I ain't do
conduct.
nothing.
Now you're still
I ain't do nothing, man.
yelling and screaming.
I ain't do nothing, man. Hey, he ain't even saying why he's doing this, bro.
I just told you, you're under arrest for disorderly conduct.
I'm not. I didn't do nothing wrong, man.
You're yelling and screaming.
I'm telling them if you kill me,
I
I did
even
nothing wrong.
informed you, if you continue to yell and scream, you're going to be placed in custody.
I was informing them, man. Nah.
You were screaming across the entire campus about us killing you. I do not know what the issue is, sir.
Me neither. Why you stop me?
I've explained that to you how many times? You may disagree with
Hey,
it.
ask him why he stopped me, man.
Stand still.
Stand by just one.
So again, do you feel that Mr. Phillips was being unreasonably loud? Because ultimately that would be considered a question of fact as opposed to a question of law and would be determined by a jury. Which brings us to the part of the case that really intrigues me, which was the behavior of the judge ruling over his case.
How do you want to plead?
Not guilty. Like to be appointed lawyer.
You have to get your own. You got a full-time job. It's for people that are on.
Excuse me, I can't hear you.
You have a full-time job.
I don't have a job
Well,
because
then
of
you
this.
need to get one. You're not on disability, so you'll have to get your own attorney.
But it serves
Plus, I
time.
don't think you were offered diversion, so I don't think he's gonna.
Because I'm
There's no
innocent
jail
till
time.
proven guilty.
Neither charge qualifies either way. It's something that's $500 or more, and or up to, you know.
But I need some time to get my witnesses and all that.
Yeah, sure. I'm gonna put it for a pretrial first,
Okay.
and I'll get you something.
This is the first time that Mr. Phillips requests a court-appointed attorney. The Sixth Amendment to the United States Constitution guarantees your right to counsel. But it wasn't until 1963 when the United States Supreme Court held in Gideon versus Wainwright that indigent individuals who could not afford an attorney were entitled to have one provided at the state's expense. There are obviously some rules restricting who is entitled to a free attorney and who is not. First, deprivation of your rights must be at stake. This would require that the state has to provide an attorney whenever substantial jail or prison sentences are in play. Second, you must truly be indigent. In Kentucky, that requires the individual to be able to show that they cannot truly afford an attorney. The judge at this point is, in my opinion, not able to determine if Mr. Phillips is indigent or not. I would be absolutely okay with her ruling if she required some type of proof and documentation of his inability to afford an attorney, but she just shuts him down. Let's fast forward to the next hearing where he asks yet again for a court-appointed attorney.
That's our offer today.
I would like to request for a public defender. I got an affidavit as well.
You got a full-time job. You don't.
I don't have a job, ma'am. You're not even giving me a chance.
I'm sorry, Mr. Phillips, you don't qualify.
Well, I'd like to have a continuance for pretrial, please.
And he asks again at the third pretrial conference hearing.
Turned in a paper, an affidavit
What? I'm sorry.
an affidavit of indigence, and I turned that in.
No, there's not. You wouldn't qualify. It doesn't fall. It's only where the fine meets or exceeds $500 or there's active jail time involved.
Yeah, it is.
Neither of
It
this.
is.
You'll have to get your own attorney.
Is disorderly conduct jail time?
There's no recommendation of
He'll
active jail
dismiss
time.
on the unattended. If you plead to the disorderly, it's 45 days, all which will be probated, 2 years on the condition you have no other disorderlies.
Essentially, the judge's position is that because he is being offered such a sweetheart deal of diversion and or non-reporting probation without jail time, his liberty is not at risk of being deprived. The issue is that Mr. Phillips feels like he is innocent and wants his day in court. By demanding a jury trial, if he were found guilty, he could very well be looking at the full 90-day stay in the county jail. Therefore, in my opinion, he should be entitled to a court-appointed attorney if he is truly indigent, which I have no way of confirming or denying at this time. This, however, is when the case gets really weird, as Mr. Phillips, representing himself pro se, files motions to dismiss based on lack of probable cause, a demand for a jury trial, and a request for a suppression hearing, and the prosecution then offers the diversion program yet again.
Mr. Phillips, why don't you just go to diversion?
Excuse me, ma'am.
You were eligible for diversion. Why don't you just go? That way, you can get it over with right away, and then you can get it off your record right away.
With no disrespect, because I'm innocent.
I'm taking. I'm just saying.
I'm
you want to
innocent.
So, sir, did you want to take
I'll set it down
or
for
set it
suppression. That'll be on.
So what about the dismissal? You denying that?
Oh, motion to dismiss is denied.
See, I figured that. And can I ask you a question, Your Honor? No disrespect.
None taken.
Are you biased?
Really?
No, I'm just
I don't know.
asking.
I've been on this bench. I'm the only woman that was here. You know what? You know, women have as much discrimination as you do, and it's even more.
I'm not talking about the color of my skin.
I do take offense.
I apologize. I wish you
because I
did.
knew you were going to since the day you came in. So I know what your plans
What
are.
is my plans?
You watch the news. I watch the news. Yes, it is.
What are my plans?
Yeah. Just what you just said to me.
I'm just asking.
Suppression will be scheduled on October 22nd at 10 a.m. back here.
This is not a question that I would advise anyone to ask a judge in a court of law. However, her answer, in my opinion, does display clear bias by her words stating, quote, "I knew you were going to since the day you came in," end quote. She further asserted that she knew what his plan was. This seems to be a bizarre response to me that alludes to her having some type of bias if she is going to assume that he has some type of nefarious plan just from looking at him walking into her courtroom. Mr. Phillips then files a motion for her to recuse herself from the case, which is considered in conjunction with the suppression hearing later on.
Here today, I guess we have two motions, one for me to recuse. There's no affidavit, no substantiating anything for me to recuse. I don't know anything about your case. You put it in your head of something, I have no idea, but that motion will be denied. I'm not.
I asked you, was you biased, and you confirmed that you was.
I'm not the least biased person you
I just
will
go to
ever
the
meet.
top.
And you know
Go
what?
to the top.
I'll send you to one of the other judges. What do you think? Judge Grayhouse or Judge Eastland?
Doesn't
Which one do you
matter,
think?
as long as they're not you,
Okay.
'cause you're
The
biased.
motion to recuse is denied. You have no supporting data, and you have no idea who I am, that you just pull it out of
You
the
got
air
the
that I'm
paperwork
biased.
that I
You know what
turned in?
think? I think you're biased.
Did you
and
get
you're
the
biased.
paperwork that I turned
So,
in, ma'am?
I'm telling you, that's it. That motion's denied. So we're here today on your motion to suppress. What is the issue for suppression?
He had no probable cause whatsoever.
Have a seat. We'll go ahead and have that hearing.
This is already a much longer video than I typically like to create, and I'd love to go through the suppression hearing, but I don't have time for it right now. If you'd like to see me go through the suppression hearing in detail, please let me know in the comments below, just so that I know it's something you'd actually be interested in. Suffice it to say, Mr. Phillips' efforts were less than skilled, and the motion was denied. But it led to this exchange between the judge and Mr. Phillips, where he asked yet again for a court-appointed attorney.
I got an affidavit too requesting a lawyer based on my situation.
I'm just.
You're not even looking at it.
I'm telling you, you have the same. You will be held to the same standard as every other
But if
person.
I have an affidavit, you don't look at it. That's what goes on?
Affidavit for what?
What I just said, I request for an attorney because of my hardship.
Well, they're not recommending jail time. There's certain specifications for a public defender, okay? Which you first of all, the case doesn't even rise to a level where a public defender would be appointed. They're not recommending any jail time, and it's a B misdemeanor. So those are cases where a public defender can be appointed is a case where the fine meets or exceeds $500, or there is jail time involved with the charge.
Let me make sure I understand. So
Okay,
you say there's no jail time
also,
involved in this?
Oh yeah, and if that jury recommends 90 days, you're going to jail for 90 days.
So that's why I'm trying to request a lawyer.
No, you have a vehicle. You're not on disability.
I am disabled.
You are.
You're not even looking. I turned the paperwork in, man.
You collect disability?
I turned the paperwork in.
No. Do you collect disability?
I turned the paperwork in.
You're on Social
If you look
Security
at the paperwork, it's going to
Are you on
tell you
Social
that.
Security? No, you didn't answer me. You do not qualify. They're not
You looked at the
recommending,
paper?
they weren't recommending any jail time. In fact, you are eligible for diversion. You are not eligible for a public defender.
So you're not looking
And that's
at
being
it. So
denied.
you're not gonna
Your
look
jury
at
is scheduled for February 13th at 9 o'clock back here.
All righty.
Okay?
Circuit court.
Better watch out, Mr. Phillips. I have a tendency to get a little...
Excuse me, ma'am, I didn't hear
That's
you.
it. That's it today. Okay? Wally, getting's good.
You told me to watch out, right?
No.
I heard that.
The judge's argument for his ineligibility makes no sense to me. You are entitled to a court-appointed attorney if you are facing a risk of substantial jail time and you are not able to afford an attorney. The judge admitted that if the jury finds him guilty of disorderly conduct, he would be going to jail. So the only remaining element is if he is truly indigent or not. Requiring proof of indigence is completely reasonable, but not even looking at his affidavit, attempting to prove his hardship is a major issue for me. However, according to Mr. Phillips' YouTube page, the disorderly conduct charge was eventually dropped before trial, and he ended up paying the fine for leaving the vehicle unattended. In this case, Mr. Phillips was rightfully ticketed for leaving his car unattended. The disorderly conduct charge could come down to a jury deciding if he was making unreasonable noises or not. But the big issue that I have is with the judge, not even looking at his argument for a court-appointed attorney to be provided. I could go into a lot more detail about this case, but again, this is already a longer video than I intended to make. If you'd like me to evaluate the suppression hearing in more detail, then please leave a comment to let me know that this is something that would pique your interest. In the meantime, remember that no matter who you are, you have value and you have rights. Do not be afraid to use them, and we'll see you next time right here on Legal Dissent.